everything. Then let's have a look. The next question. So the next question, again, paraphrasing, just so it's quite broad. This also happens often in practice, although not as often as the first one. But it relates to not being able to find a tenant that you have a deposit to pay to. In fact, not to lie, I don't think I've ever experienced this, save maybe for 1 or 2 times. So the agent has money, or the landlord has money, has the deposit, and apparently the tenant must have been so great that, you know, maybe the property wasn't damaged, paid all his rent on time, and now simply left, and no one can get hold of him anymore, yet there's a deposit that's due to him. The lease agreement does specify the banking details, so that's one upside. So it does actually have banking details, but no one can actually confirm or verify these with the tenant. And it does sometimes happen. Let's say a tenant's been there for 5 years, as an example, and you just want to confirm that you're actually paying it into the correct account, or not his ex-spouse's account, or boyfriend, girlfriend, that sort of thing. So Nick, from your side, in a situation like this, what would the best solution be?
Yeah, so I agree with you, Bruno. It's an interesting circumstance. Most people don't forget that they're holding a deposit and they want to make sure they get it back. But we have to remember, in terms of the Rental Housing Act, there are certain obligations that are placed on the landlord in the circumstances, or if the landlord has authorized an agent to hold the deposit, they fall under this as well. And there is an obligation to pay back the deposit to the tenant in terms of legislation. That time period will change depending on whether there was damage on the property or not. Okay, so if the property was perfectly fine, you've got to pay it back within a certain period. If the property was damaged, you're obviously entitled to utilize the deposits to pay any outstanding amounts. And then after rectification of the property is done, you have to pay out what remains of the deposit to the tenant. But there is a legislative obligation on you as a landlord to do so. Luckily, in this particular circumstance, and this is a very much good practice to do as a landlord, banking details for the tenant have been provided for at the start of the lease agreement, which in terms of those details that have been acquired, the lease agreement is going to require that they're paid back into that account. And in this circumstance, even if you weren't able to contact the tenant, I think you'd be in the right position to just pay into the banking details that have been provided to you in terms of the lease agreement. If the tenant at any point had changed their bank or whatever the case is, they ought to have notified the landlord in the circumstances. So simply paying the deposit into that account, even if you can't get in touch with the tenant at this point, would fulfill your obligations in terms of the legislation. So I would go ahead and simply pay into that particular account, unless there's some we haven't been provided this, but unless there's some other reason that you have a suspicion that the bank might be compromised, or there is a reason that it shouldn't be paid into that particular account.
Do you have, just out of interest, do you have any suggestions for a situation where there is no bank account?
Look, so if there is a circumstance where there is no bank account, okay, and you don't know where to pay this particular money, what you're going to have to do as a landlord is continue to hold the money. Yes, there's a legislative requirement on you to pay it to the tenant. But remember, the legislation dictates one thing, but it's not the only factor that's taken into account in terms of law. And factual circumstances always matter in a particular case. So even from a legal perspective, we know what the law is. It says exactly what it is, but those legislative requirements must be taken in light of the factual circumstances of a particular case. If you do not know the banking details of the tenant and you can't get in touch with the tenant, you don't know where they are, it's simply not reasonable to expect that the landlord goes ahead and pays into an account that they don't know. So in those particular circumstances, there would be a justification, in my view, for the landlord to continue to hold the money. The only thing I want to mention there is be very careful. That is not the same as being able to take the money. Okay, deposits, we've dealt with this before on the channel. Deposits while they're being held by the landlord, are not the property of the landlord. They continue to be the property of the tenant throughout the subsistence of the lease agreement. And that is why, in terms of legislation, any interest accrued on that particular deposit are also payable to the tenant in the circumstances, at least in respect of residential lease agreements. So please do not think as a landlord that if you can't find your tenants, he's gone, you can immediately appropriate and take their money. That wouldn't be a right in the circumstances, but you would certainly be able to continue to hold that money to eventually see if you do get in contact with them. And as I say, I would continue to try and get in contact with the particular tenants in the circumstances.